Hello everyone, welcome to IPM IAS Academy's topic specific current affairs session. In this session, we are going to discuss about the criminal laws and the big picture. Okay, so basically certain criminal law bills were introduced in the parliament in the last session and we are trying to understand the general picture regarding that particular bill. So three important bills were introduced. One is Bharatiya Sanhita, then Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Suraksha bill. And these bills are trying to replace the existing Indian Penal Code of 1860, the Code of Criminal Procedure 1973 and the Indian Evidence Act 1872 respectively. So these are the acts which are going to be replaced by these three important bills. So in this context, let us try to understand more about the Bharatiya Nagarik Suraksha Sanhita. The Bharatiya Nagarik Suraksha Sanhita 2023. So this was a bill which was introduced in Lok Sabha on August 11, 2023 and the main objective of this bill is to repeal the Code of Criminal Procedure 1973 CrPC. So the Criminal Procedure Code basically provides for the procedure for arrest, prosecution and bail for offences under various acts including the Indian Penal Code. So it deals with the procedures for arrest, procedures for prosecution and procedures for bail. So what are the important changes which are going to come with the bill, with the Bharatiya Nagarik Suraksha Sanhita 2023? Let us try to understand. The first one is related with the detention of under trials. So those are undergoing trials. So under this code, if an accused has spent under detention half of the maximum period of imprisonment for an offence during investigation or trial, he must be released on his personal bond. So if an accused has spent half of the maximum period of imprisonment during investigation or trial, then that person should be released on his personal bond. So that is the first provision. And these provision is not applicable to certain sections. Okay, certain people who are actually going through trials on certain kinds of offences. So one is the offences which are punishable by death. This is excluded. And the offences which are punishable by life imprisonment. And also another section of person is like the persons against whom proceedings are pending in more than one offence. So these three kinds of people are actually excluded from this provision. But others can be released on his personal bond. So it also adds that first-time offenders will be released on bail if they have completed detention for 1/3 of the maximum imprisonment which can be imposed for the offence. Okay, this is regarding the first-time offenders. If they have completed detention for 1/3 of the maximum imprisonment which can be imposed for that particular offence. So who is taking care of the procedures regarding the release of such under trials on bail? So it is the superintendent of the jail where the accused is detained. So this is regarding the first time offenders. So this is the first provision or first change that is going to come with the Bharatiya Nagarik Suraksha Sanhita 2023. Trials in electronic mode, very important. So trials which are going to be in electronic mode, what are the changes in that area? The bill provides that all trials, inquiries and proceedings may be held in electronic mode. So it is actually approving that the trials, inquiries and proceedings can be held in electronic mode. It also provides for the production of electronic communication devices likely to contain digital evidence for investigation, inquiry or trial. Electronic communication includes communication through devices such as mobiles, computers or telephones. The bill is giving more access. It is actually exploring a very bigger area. Okay, it is actually making the process much more simpler by giving access in the electronic mode because it provides for the production of electronic communication devices likely to contain digital evidence for investigation, inquiry or trial. So that is another change which is going to come, trials in electronic mode. The medical examination of accused. So medical examination of accused, what are the changes? Let's see. The code allows conducting a medical examination of the accused in certain cases including the cases of rape. Such examination is carried out by a registered medical practitioner on the request of at least a sub-inspector level police officer. So it has to be requested by a sub-inspector level police officer, and who has to conduct this examination? A registered medical practitioner has to conduct this examination. The bill provides that any police officer can request for such examination. So just see the change. The earlier the code was giving permission for only the sub-inspectors. The request can be made by the sub-inspectors or sub-inspector level police officer. But here with the bill, they are saying that any police officer can request for such an examination. So that is the change which is going to come in this area. Now forensic investigation. Forensic investigation. What is the change? The bill mandates forensic investigation for offences punishable with at least 7 years of imprisonment. So the bill is saying that forensic investigation should be done for offences which are punishable with at least 7 years of imprisonment. In such cases, the forensic experts will visit crime scenes to collect forensic evidence and record the process on mobile phone or any other electronic device. If a state does not have forensic facility, it shall be the duty of the state to arrange that facility from another state. Okay, so this is regarding the change which is going to come in relation with the forensic investigation. Then comes the signatures and finger impressions. Okay, the code empowers a metropolitan or judicial magistrate to order any person to provide specimen signatures or handwriting. The bill expands this to include finger impressions and voice samples. So already in the code there were provisions for collecting specimen signatures or handwriting was there, but with this bill they have expanded the scope. They included some more things, that is like finger impressions and voice samples. These samples may also be taken from a person who has not been arrested. Okay, very important. So this is regarding the collection of signatures and finger impressions. Then comes the timelines for procedures. This is also important. Timelines for procedures. The bill requires medical practitioners who examine rape victims to submit their report to the investigating officer within 7 days. So within 7 days, the medical practitioner has to submit the report based on the examination done on rape victims. Other specified timelines include giving judgment within 30 days of completion of arguments, and it can be extendable up to 60 days. Informing the victim of progress of investigation within 90 days, and framing of charges by a sessions court within 60 days from the first hearing on such charges. So there are a lot of changes which is going to come in terms of the timelines for the procedures. Then the trial in absence of offender. Okay, a trial in absence of offender. The bill provides for conduct of trial and pronouncement of judgment in the absence of a proclaimed offender. So in the absence of an offender also, the judgment can be pronounced, the trial can be conducted. This shall be done when such a person has absconded to evade trial or there is no immediate prospect of arresting him. So if that person is absconded, or if they see that there is no immediate prospect for arresting that person, then this trial in absence of that offender can be conducted. Then proclaimed offender refers to a person who is accused of an offence punishable with imprisonment of at least 10 years or death and fails to appear at a specified time and place as specified by the court. So here we are talking about a proclaimed offender. That proclaimed offender is an accused of an offence punishable with imprisonment of at least 10 years or death, or that person fails to appear at a specified time and place as specified by the court. So these are the important updates or important changes that are going to come in the criminal procedure code with the bill.